Hi friends, the term to be discussed today is applet board. This is Bindu Sharma from Origin. Purpose of this series of videos, Key Terms Patent Act, is to understand important terms that are used in patent law. The term applet board has been defined in Section 2 of Indian Patents Act. Applet board, according to Section 2, means the applet board referred to in Section 116, and we will go through Section 116 as well. Applet board has been given variety of powers to deal with appeals pending from various high courts as well as appeals against decision of the controller. Section 116 is applet board. We also call it as Intellectual Property Appellate Board. IPAB is a specialized tribunal set up by the government for deciding appeals to the decision of the controller and other related matters on patents such as revocation of patents. IPAB has its headquarters at Chennai and shall have sittings at Chennai, Mumbai, Delhi, Kolkata and Ahmedabad. Objective of having IPAB is to have speedy disposal of the appeals and rectification of applications which were pending in various high courts. IPAB handles appeals from decision of the controller as well as various high courts. IPAB comprises of chairman, there are technical members, and there is other staff to take care of all the activities of IPAB. In case of patents, most of the times subject matter is very complex and scientific in nature, and that's why there have to be technical members in the appellate board. Technical members of the appellate board, they shall have at least 5 years held the post of controller, or for at least 10 years functioned as a registered patent agent and possess a degree in engineering or technology or a master's degree in science, or should have at least 10 years experience working as an advocate in practicing law relating to patents and designs. IPAB is a kind of tribunal or quasi-judicial body. Tribunal is an individual or organization which has powers resembling those of a court of law or judge and is able to remedy a situation or impose legal penalties on a person or organization. Some examples of tribunal are IPAB, Intellectual Property Appellate Board, Income Tax Appellate Tribunal, or Railway Claim Tribunal. They all are quasi-judicial bodies. Under Section 77, the controller is vested with certain powers of the civil court. Controller is the quasi-judicial authority, and in any proceedings before him, he shall have the power of a civil court. Section 117, Staff of Appellate Board, says that the central government decides upon the staff of Appellate Board and salaries of the members. Section 117A, Appeals to Appellate Board. This says that the orders of the controller or central government can be appealed in IPAB. Now, since most of the orders can be appealed, there is a set of orders which cannot be appealed. The orders passed by the central government in relation to inventions relevant to defense purpose and orders of the controller giving direction of secrecy in respect of such inventions under Section 35 and revocation of patents by the controller under Section 65 are not appealable in IPAB. Let's take some examples where the decision of controller can be appealed in IPAB. For example, decision of controller related to divisional application, opposition to grant of patent, amendment in patent specification, surrender of patent, some provisions of compulsory license, revocation of patent for non-working, it also comes under compulsory license, restoration of lapsed patent, licensing of related patents. This again comes under compulsory license topic, and termination of compulsory license. There are many more decisions of controller that can be appealed, but these are some of the examples that you can remember quickly. There is a timeline to appeal in appellate board, and section 117A appeals to appellate board says that every appeal shall be made within 3 months from the date of the decision, order or direction of the controller or the central government. Section 117B Procedure and Powers of Appellate Board. This section says that the provisions of section 84, 87, 92, 95, 96 of the Trademarks Act 1999 shall apply to the appellate board in the discharge of its functions under this act as they apply to it in the discharge of its functions under the Trademarks Act 1999. Section 117C Bar of Jurisdiction of Courts etc. says that no court or other authority shall have any jurisdiction, powers, or authority in relation to the matters referred to in Section 117A, subsection 2, Appeals to Appellate Board, and Section 117D, Procedure for Application for Rectification etc. before Appellate Board. Next is Section 117D, Procedure for Application for Rectification etc. before Appellate Board. Now, if there is any decision given by Appellate Board, the same has to be communicated to the Controller of Patents. The section says that certified copy of every order or judgment related to the revocation of patent or rectification of register by appellate board shall be communicated to the controller so that controller can implement the same and make necessary changes in the register of patents. Controller can appear in the proceedings before appellate board. Section 117E Appearance of the controller in legal proceedings says that after the appeal has been made to the appellate board against decision of the controller, the board will carry proceedings and the controller may appear in such proceedings before the appellate board. Section 117F Cost of controller in proceedings before appellate board. The section says that in all proceedings before the appellate board, the cost of the controller shall be in the discretion of the appellate board, but the controller shall not be ordered to pay the cost of any of the parties. When appeals are filed in appellate board, it is choice of appellate board to start the case fresh, or they can start the matter from the stage it has been transferred to the appellate board. Section 117G Transfer of pending proceedings to appellate board says that following cases shall be transferred to the appellate board by the central government, and the appellate board may proceed with the matter either de novo or from the stage it was so transferred. The word de novo means starting fresh. Appeals against any order or decision of the controller and all cases pertaining to revocation of patent other than on counterclaim in a suit for infringement and rectification of register pending before any high court. Appellate board has powers to make rules, and section 117H Power of appellate board to make rules says that the appellate board may make rules consistent with this act as to the conduct and procedure in respect of all proceedings before it under this act. I hope this topic IPAB is clear to you now. In your patent agent examination, you can expect some short answer type question from this, or you can even expect some multiple choice question from this. Question for today is every appeal to IPAB should be made in prescribed form by paying prescribed fees within the period of first option is 1 month, second option is 2 months, third option is 3 months, and fourth option is 15 days. You can put your answer in the comment section below. Thank you for watching this video. For any queries related to our services, you can contact us. Email ID and phone number is given in the video description. See you next week. Till then, keep learning and keep innovating.